Hello, good morning, everyone. Welcome to Intellectual Property Strategy session from EIT Urban Mobility. Okay, um, we are pleased to welcome you to our third info session in Strategic Innovation Call, which is dedicated to preparation, drafting, and submitting intellectual property strategy within your proposals. My name is Maya, and I'm an IP legal counsel in EIT Urban Mobility, and also I deal with protection, monitoring projects and results in the projects, data governance, and AI governance. Well, to start with, before we move to the context and give you a bit of flavor of what's actually IP is about, I would like to provide a bit of statistic, and this slide is basically highlighting the relevance, the attractiveness, and the need for protection of intellectual property assets within your company and for your solution. For instance, according to the latest studies prepared by European Patent Office, European Trademark Office, and European Commission studies, we can see that the very fact of protection of your solution, your technology, gives you have seen as a positive impact, gives you more reputational, improved reputation on the market, notwithstanding the fact that only 10% of SMEs are having registered IPRs. Over 68% of this SME enjoy high revenue per employees with registered IPRs, meaning that the fact that IP is registered and technology is protected gives a better positioning for your company on the market and among your competitors in long-term business perspective. Okay, so if we move further, we will also see the very latest statistic from European Patent Office this year on leading fields of technology with registered IP, particularly patents. However, of course, IP is not only about patents, and we will talk about that later. So we see that computer technology, electrical machinery, energy are going up in registrations from last year, and also transport. And a bit more about incentivizing and explaining the rationale behind protecting your solution. That's basically funding and exit performance for European startups, meaning that startups that register IP according to mentioned studies facilitate the route to financing and to become more attractive for their investors. So they have more than twice a high likelihood of successful exit for investors. So these are the reasons to take this part of your proposal seriously, and try to and here we will try to guide you on how to address the main questions that we have in IP strategy, and explain more or guidelines that we give to applicants how to approach IP strategy in the proposal drafting. Okay, so basically we will address two questions here. Of course, if you have any question during the session, so we have chat functionality, and you can use this chat to ask questions, which we will address at the end of the session. So basically two blocks of questions, the concepts to very briefly to stay on the very same page when we are talking about IP and IPRs, rights or assets, and how to address IP in your proposal, examples, good bad practices, and what basically we mean under the strategy. Okay, the concept of IP. Yeah, if we talk about IP, we are talking about here about intangible assets. So basically, or value that bring your technology, your solution, your innovation to your business, which is not tangible, right? So it can be creation of might. Normally, people create, right? Within AI age, of course, we can discuss. It's an open question, but currently we are talking about people who are creators in different fields or industries, in scientific, literary, artistic, industrial field, and so on. So uh, we can categorize intellectual property assets within as inventions, know-how, trade secrets, mainly in industrial field, or designs for appearance of any product, or artistic works, right? But also with that, we have company reputation, brand value, which also can be categorized as intellectual property, industrial property. In addition, we do have not traditional understanding of IP, which means the knowledge or even people as an asset within the company. It also can be considered as an intangible asset of your business. And intellectual property rights, that's basically the tool to shield, right? They work as a shield for your assets, intellectual, intangible assets. That's when we are talking about patents, trademarks, design rights, utility models, copyright, trade secret, and so on. So to understand the difference between IP or intangible assets and the rights that protect these assets, which are patents for inventions, designs for overall appearance, trademarks for branding and logo, and protecting commercial efforts. Copyrights for software. Sometimes we can discuss if there is a technical element in your solution, so it can be registered as a patent, protected by patent, depending on the algorithm and the level of implementation of this algorithm within the system. Database rights, which are also important, especially in the context of our proposal when we receive mostly AI-related proposals or SaaS or service as a mobility as a service solutions and so on. So basically, these rights are more common for the proposals that we receive. Yeah, so assets and tools to protect these assets. And there's a bit more explanation about subject matter. So patents normally protect inventions within technology involving inventive step and industrial applicability and novelty. So that's our basic understanding of invention, and only invention can be protected by patent, right? So it gives you exclusivity on the market, which can be used aggressively or as a negotiation or as a deal maker. We will discuss this later a bit too, how to use patents for in commercialization of your IP assets. Benefits, incentivizing innovation because of disclosure, right? Of the patent. When you patent, you disclose your innovation. Making possible for other innovators to build upon, to improve, and so on. protection of knowledge and monopoly, of course. So in return, you will get monopoly on this technology. And duration. A monopoly is not infinitum. So we have 20 years in Europe for protecting. Normally, it's 20 years globally, with some exceptions. Okay, so trademarks, that's very common and let's say agile IP right that can protect the platform effort, the platform branding, your company branding, logo, commercial effort that you make within different products. So it depends on the context, of course, how far you should go, you can go, and you would like to go with the protecting of your commercial effort. So we are talking here about distinctive signs to be recognizable on the market. So they are also exclusive, meaning that you can enforce them as a monopoly when there is a similarity, not only identical marks, but similarity too. The very benefit is promoting competition and providing awareness at your brand. And of course, making money with this IPR too. So we have 10 years for trademark protection, but of course, the beauty of trademark that it can be actually infinitum. We know examples of infinitum trademarks, meaning that every 10 years, once you renew, paying fee, you can have it for more 10 years. Yeah, so with extensions. And designs basically protecting the overall appearance of the product, and if your solution is dealing your solution is dealing with improvement or overall appearance or any design elements that you would you think they are unique and original, that then we can use design to protect them. Also, it can work for user interface, apps, and so on. So it's also exclusive right, and it's not that let's say not that hard to achieve it as to get this right as a patent right, and it also gives you monopoly and possibility to enforce this right in different way. And we will discuss it a bit later with the possibility to extend, but with maximum 25 years. Okay, copyrights, automatic rights, which can normally protect software, but it also depends on the nature of your software, and trade secrecy with which depends on the valuable if if you go for patents or no. If you don't go for patents, so you stay with secret, but then you have to protect the secret properly. Okay, so IP deal, monopoly rights. So you disclose your innovation when you patent, not by the very fact of applying, but in specific time frame when there is assessment of 3 steps and so on. But still, the disclosure will happen. Meaning that the public will consult your technology and improving innovation, and in return you will get a monopoly, getting with the possibility to commercialize your patent rights and ensuring return from your investment in the solution. Okay, so here, so that's the basic, okay, of intellectual property law, let's say, in Europe, and more or less that's harmonized cross-border. And in Horizon Europe perspective, of course, IP rights, they are of high importance in the context that basically they are of essence of the project, because all that the project is aiming, that's innovation, and IP rights, that's the shield for innovation. Yeah. So in the meaning of building, drafting your IP strategy, we have several recommendations and guidelines from European Commission, Horizon Europe rules, Annex 5, with all details and requirements, where the conduct of practice of an IP management when you can dive more and read more about the approaches and the requirements for IP protection and best practices. But the very essence is that um, protection of your innovation when when you when we deal with Horizon Europe projects, it's paramount. Yeah, so it should be taken seriously at the very initial stage of the project, distinguishing between background IP, foreground IP, collaborative efforts, and understanding the ownership and further commercialization path. So where is localized IP within the Horizon Europe project? So basically, at the very beginning, when you draft your proposal, you should identify which is owned already by you and which elements of innovation or technology will be developed during the project in a collaboration only by you, third party, so it should be defined. Um, so during the project, there will be a project plan when you will address the tools that you are going to implement to protect your technology, which can, of course, highly depend on the context of nature of your technology and solution. It can be trademark as a most common one to protect at least the branding and commercialization effort of your platform and your business. Depending on the nature, it can be a patent application, utility model, which is a bit softer instrument, and design rights for apps, for gadgets or hardware that you are developing. Also, IP sits within the dissemination and communication results, meaning that before disseminating anything, you have to decide on the destiny of protection. So, meaning if you're planning to protect your solution via patent, there cannot be any disclosure, of course, before the application process. And so that's also essential decision to be taken before dissemination, communication, and ownership. Of course, it should be also aligned between all partners who owns what in the very beginning. And basically, when the project ends, we have and the market innovation are going to the market. So that's also the fact should be taken into account which level of protection is granted already, which is in process, in order to ensure that your solution is not infringing third-party rights, which are already on the market. And just a brief comment here, as of course slides will be shared with you after this session, including the recording, so you can read them more in details. But the very idea that IP or protection of your solution should be considered at the very start, from the very start, during the first project outputs, during communication activities, and after the project ends. So we do have specific reporting obligations in terms of mandatory results ownership list, which should be delivered by the end of the project, meaning that partners decide who owns what, right? So, and after even there is a post-grant reporting, meaning that if your solution or the project's results are not commercialized, are not exploited as they were expected to be exploited, then there is obligation to inform granting authority about this fact and decide what to do with these project results after the project ends. So IP start with inputs, meaning that it's not only patents. Okay, so every expertise, solutions, know-how that you bring to the project, it's already your input. And according to the Horizon Europe rules to Annex 5, and also it reflected in our IP policy, which is posted in our website, that the results of the project are owned by the entity which is developing these results, right? So if there is a presumption, okay? So if your company is developing this solution by itself or building collaboration, so there is a presumption that your company is an owner. Then the results can be as, for instance, the platform itself as a logistics solution, or you can come up with an invention as a result of the project, or improvement of the invention. Normally, it's 90% for patents on improvements, right? So that's the result itself, and after by the end of the project, we should reflect the impact. So successful implementation. So it's not only about results, about the post project life of your results, meaning to show successful implementation or improvements of that you claim to have, you will have in the very beginning, putting your product or solution into the market. Yeah, so the impact when you will draft your proposal, including IP strategy, the impact justification should sit there every time, explaining why long-term effects, contribution, and how you will use the result of this project. So the very message from Horizon Europe rules, let's say that the applicants, the beneficiaries of grants must apply their best efforts to protect and commercialize IP assets within the project. Yeah. Okay, now we are moving to the second part. So that was the general explanation of the context, let's say, of IP and IP in Horizon Europe projects. But now we dive more into the specific proposal requirements and expectations from the applicants, how to address IP in the very beginning, and when you're successfully selected for the call for the project, how to address these during the project journey. Okay, so as I mentioned before, we have posted on our website, along with call manual and explanation of IP strategy there. We do have specific link to IP strategy checklist on our web page when you can read and dive into the questions. So the first disclaimer, you should not have all questions addressed in your strategy. It all depends on the nature of your solution and your technology. But of course, some fundamental questions like ownership, for instance, or the level of protection current one should be, of course, addressed in your strategy drafting. Of course, the wording in the application is not allowing to draft there a lot, but at least to have it summarized, like a summary, and to be ready to provide more details upon request, and once your proposal is selected, to justify these plans or strategy plans claimed by action. Yeah, for instance, applying for trademark, applying for design rights, preparing FTO study, and so on. Okay, so if we look at call manual section 3, call requirements, so basically the topics are addressing innovative solutions, meaning new product components, improved functionalities, so on, meaning that's all about your IP, right? IP assets. Um, Also, you should bear in mind that the technology level, readiness level, we expect, as was already mentioned in previous session, I think that we need to bear it in mind anyway all the time that it should be close to the market. So we do not accept like early stage solutions which are on the idea uh, level, but a more robust, more mature solutions that are ready to be finalized and enter the market. Additional KPIs, we have marketed innovations, meaning that these innovations are expected to be protected according to certain level of innovation protection, depending. Yeah, so we cannot give like one solution fits all, right? But it will depend on the nature of your solution, of course. But the requirement is to have your solution protected by the area. And yeah, so not necessarily at the very beginning to have a patent. If you have it, that gives you competitive advantage, definitely. But by the very end, to understand the action taken during the project in terms of protecting your innovation and the actions that are planning to be taken, but with justifications like applications, references to the registries from patent office, from trademark office, design office, other measures, alternative depending. Okay, Section 3.8, intellectual property strategy itself. So when details can be consulted in a checklist, and mainly they are addressing the IP landscaping, and I will explain now what do we mean under IP landscaping. Also measures to protect these IP assets, and depending on the context, if it's if it's normally a hardware solution or highly competitive market that you will enter. So the FTO, freedom to operate analysis, can be requested on the further stages. And last but not least, during the evaluation process, evaluator will take into account the level of detail that you provide when you draft your IP strategy, and addressing when you will address novelty of innovation, meaning that when you provide robust, well-written, efficient freedom to operate, to justify that you will not infringe others' rights, that you made your homework on competitors and you compare their technology and they will not block you from entering the market. Or you can provide patent applications that are not patents yet, not to be confused with patents, because we often hear that we have a patent, but when we dive, we see only the very initial stage of patent application, which should be, of course, explained in the very beginning that it's not a patent, it's an application, which is also good, but to be clear, or trademark clearances, so the initial stage of assessing your branding protection and commercial efforts of your business. Impact, so IP is also there. When evaluators will assess the impact, they will also take into account the protection measures during exploitation, dissemination, and commercialization strategy points. So basically, when you draft your proposal, you explain what you have, right? So that's assessment, meaning you explain that we have the certain technology which consists of, for instance, algorithm, AI algorithm implemented into the platform when we collect data. So we have branding, protected or not. We have certain protection for algorithm, copyright, or a patent application, depending on the context. We have secret around these algorithms which are properly protected too. So that's IP escaping means that we are assessing. Basically, that's your own business intelligence approach to assess what you have and what is the value of your solution and business model in general. Protection, so IP rights. So there in the strategy you say we have certain these assets, IP assets, and then we protect these assets via these or are planning to protect during the project. Okay, via specific IP rights, patents, trademark, design, secrecy, copyright, and commercialization. So to make your IP assets work as innovation, so there should be commercialization in industrial applicability path, let's say. Um, and you explain how are you going to manage your IP assets slash rights, uh, saying that, okay, we have this solution, we are planning to protect it via 123 patent, utility model and design, and trademark, including for platform. So in order to enter the market, we are going to license or we are going to sell or to partner to attract investors. So basically, these elements of your strategy should be also aligned with your general business strategy and a commercialization strategy, which is also requested at a specific stage. Examples. Yeah, so normally we receive either hardware-related solutions in urban mobility industry or service-related solutions. So how you detect IP assets? So you describe, right, that the level of description can be a summary in the application, but as I mentioned, you should be ready to provide a more detailed description. So software for product technology, explaining what actually do you mean under software. So technology or improving a database, website interface, content of that website, that's all assets. So hardware, and you explain how you are going to protect this. So you mean we have secrecy on the hardware design, which we improved, and so on. Or it's a new technology or improvement of existing one. And of course, brand's reputation, so as a recognition on the market. And then you explain the tools, the rights that you're going to use to protect these assets, like copyright designs for or patent for computer implemented software. So it depends if your software is deciding technical problem. We can talk a lot about that. I won't dive there. But there is a possibility to get a patent even in Europe. Because in US definitely, but in Europe you can also have a chance to do that depending on the technical problem that your software is solving. Hardware, normally they are patents, utility model as a soft, agile tool to protect your tech improvements. Design rights, if these improvements deals mainly with the appearance of the product and some design elements. And of course, trademarks, design, copyright for reputation, and slogans, marketing, and content of your website. The same works for MaaS, for mobility as a service solutions. So normally the main asset, of course, that's data. So databases, apps, how you're going to protect these valuable assets to identify them, of course, algorithms to identify, and brand's reputation are everywhere in every business model, I would say. And so for databases, can be design rights, copyright, tech measures, depending. We have specific database rights to protect databases in Sweden and everything in Europe too. Okay, and for technology algorithms, it's a very interesting topic, especially in the light of upcoming AI Act that will be enforced next month in August. Partially, it will be enforced. And of course, it gives extra layer of responsibility for AI developers, deployers, providers. So if your solution involves AI algorithm, which I'm pretty sure most of your solution will be, so there is a need to specify the level of risk of your AI solution according to the risk-based approach mentioned in the AI Act, to explain how you address trustworthiness of your solution, how you manage data. I don't say that you should explain everything in the application phase in a very limited wording summary, but to be ready, actually, that's business intelligence, as I said, to be ready to explain and demonstrate your compliance with upcoming new regulation in AI and data. Yeah, so how evaluators will look at your proposal? So um, basically through the lens of impact. Yeah, so when you draft your IP strategy part and IP strategy in general for your innovation, you should always think about impact. So the future outcomes of your solution when it will enter the market. So the strategy of managing your IP assets, all elements of your solution, right? So should facilitate the pathways to these outcomes to the market. So it should be comprehensive, of course, the approach that you will take into the management, feasible, realistic, right? Uh, exploitation measures should be there. So it's not only about having this project and forget after the project about the results and put them into sleep. But there must be an exploitation measures explained in the initial stages and action taken during the project to make this exploitation livable. Yeah? And protection measures, of course. Yes, so you must demonstrate how you are protecting or are going to protect the results of the project. And importance and safeguards. So normally we advise our applicants to think as a responsible owner of your intellectual assets. Beyond, of course, the project, because it's not only about the project, it's your business model in general. Think about your uniqueness, right? Even though you don't have a patent, because you don't want to patent the solution, or and you go for secrecy, or you consider that your solution is not novel, or doesn't have this inventive step, okay, or the level of novelty that is required for patents granting. So anyway, you should explain which is new elements that you bring into the industry and explain the uniqueness of your solution, even though not on the patent level, but on the practical industry level. Maximizing long-term leverage from investment. That's the rationale behind taking all these measures via actions taken. So which action are you going to take during and after the project to manage your IP? That can be upscaling, licensing, access to investors. And of course, all these measures that you are explaining, planning in the very beginning will help you to avoid conflicts, IP disputes, and minimize this related risk in the future. What is freedom to operate? Of course, we all know that we need to have an assessment or have this understanding of the competitors on the market itself, the solutions available there. So that's basically a study, a research, ad hoc, narrow and of course, time dependable because we can have FTO only drafted for a certain period of time. I cannot include current applications, patent applications available, but yeah, it's hard to predict what will happen further. So of course, freedom to operate will be limited to the scope of the claim. So basically, explaining the essence, the substance, subject matter of your solution, your technology, limiting this FTO at least to the market that you are planning to enter. Normally it's Europe, but it depends on your business commercialization strategy in general. To mention there the technologies, the solutions, the innovations that are already in force, so on the market, meaning according to the patent information, and there are plenty of databases of patents, and tech experts in your field can assess this, or if you are a developer and tech expert in this field, you can do that by yourself. The company can also prepare its own FTO if the whole elements of FTO analysis are addressed in this report. And valid patents, right? Normally, we are talking about the patents that are in force or patent applications to be taken. So the very purpose is to enter the market without burdens and conflicts. Example, so in order to enter, let's say, the bicycle industry, we cannot ignore the owners of all bicycles, right? So meaning the owner of or bicycle inventor, let's say, has a general technology, open general technology that cover your technology, H2 cargo bicycle, let's say. So in order to enter this market, you cannot not ignore this technology. You should align, you should take into account when you improve this technology, explain of course, that's the level of patent application, but an FTO without disclosure of your innovation, you can also explain the differences between your technology, your innovation, and the existing innovation in the market for not to be prevented to enter this market. What if during the let's say you were selected, you were requested to provide FTO, and then you find out that a new or conflicting innovation appeared, there is a patent application or patent in force. Well, of course, this homework should have been done before any development, and I believe you all have this already at place. But that's depend of your business strategy, commercialization strategy, what to do next. So if there is a risk that the technology that already patented or in a process to be patented can block you, so that risk should be assessed. Alternative ways can be considered, for instance, redesigning the product technology or partnership licensing with the existing pioneers, or sell it, also an option. Yeah, so perhaps waiting also can be a solution. We know cases when the patent is about to expire and it was identified as a conflicting one, so the company decided to wait some time to enter the market, or challenging the patents existing. So meaning that's another long procedure to say that their patent is invalid on your rule, or infringing your technology, which was the first one. Well, but it of course depends on the situation. To summarize this, basically, the very message is that you should take IP assets seriously and protect these assets via efficient tools, IPRs, intellectual property rights. Why? Because they can be your income generators. Yeah? So via having registered intellectual property right, patent or trademark or design rights, it can depend. You can basically block your competitor, as you see via this FTO, the very fact mm, mm, of monopoly of the technology. There is a power to block. Of course, that's give you a competitive advantage on the market, um, creating design around costs for competitors when they need to avoid your technology, not to or design around or go to another market even. Um, of course, joint ventures or partnership. So you are becoming more attractive for investors or partners. Um, yeah, accelerating the growth and make it in necessary for competitors to cross license for others to come to you and ask for the license, which give you privileged position, let's say. Well, I won't go to the theory. Just wanted to show you the interesting approach to IP commercialization and decision process, which is Sullivan's decision tree when you decide what to do with your innovation. So, depending on the context, on the situation, on your level of maturity, or on the market. Niche and plenty of factors, of course, affect this decision-making process. And you can dive into it in the slides further, but the fact here that it's a step-by-step process when you decide how and when, at which stage you protect which part of your technology and which benefits you basically can get from it. And value. Value is a very tricky question of IP in general and IP commercialization and management. So, of course, we have these three approaches to any value of asset, so including IP intangible asset, but the trickiest thing that it's hard to touch. It's not tangible, right? And even the strategy for EU startups and scale-ups this year address this question in more details, and there is an action put into force to prepare a framework for IP valuation, and why the very purpose is to empower startups and scale-ups to enforce and to commercialize their IP assets more effectively and to use them as a tool for IP financing and attracting investments. So IP to the market, very briefly, yeah, there are stages to go to market for the whole innovation, including IP assets. So it's all normally contracting, making deal, negotiation, all this and IP value, as I mentioned, to understand the value of technology, your innovation, you should approach it in the specific way. So depending, can be in benchmarking in the market, so comparing to other similar technology to understand the value, forecasting for future streams, so understanding how can you use this asset as a revenue generator, and estimating the cost of development also can be an approach to understand how much did you spend during the development and implementation process. And always, as in any commercialization strategy and go-to-market strategy, we think about the buyer, right? So the potential deployers of your technology, the partners, investors. So how much are they going to pay for it? Okay, we summarize, right? So I have 2 more slides, and then you can ask me questions, if any. So question 3.8, if you look at the call, and also IP strategy checklist. So basically, you describe briefly your technology without disclosing it, of course. I mean, that's relevant for patent-related, invention-related technologies. And specify the title, the ownership bit, which is essential, as I mentioned at the very beginning, for the purpose of project management and Horizon Europe regulation compliance. Legal status, that's the second block, and we request our selected applicants to justify, to explain the ownership of the solution they will develop or they are developing during the project, because after the project there is a reporting requirement to explain what has been developed and the owners and the protective measures applied. And commercialization. So you explain in your strategy, how are you? So these three blocks for strategy, right? The third one, commercialization. So explain how these assets with this status will be commercialized, and generally addressing risks and obstacles potential in the market. And within the summary, so evaluators will look at this description and through the lens of novelty and innovation, and as through the lens of excellence in impact, which benefits will your solution bring to during the commercialization stage. And bad practice, good practice when you draft. So generalization, it's not the way. So we are all pros in ChatGPT and other relevant tools in drafting. So very general, generic, even I would say, explanation description of IP strategy will not be considered seriously, I would say. So it should be always a tailor-made approach, explaining in the essence what do you have and how do you protect it, and the price for commercialization. Also, the bad case is mentioning third-party solution when you do not have any relationship or rights authorizations to implement these solutions. Well, I think it's obvious just to mention. And intention to patent and claiming to have patent, as I also mentioned. So always be clear about the legal status of your technology, the level of protection. Either it's secrecy yet and you're considering patenting, or it's already application on the patent itself. So it should be demonstrated during the further stages. Drafting, so describe main improvements and current owners, provide info about application registered rights and due diligence, so cost, benefits, and the plans, the models that you will implement for commercialization, like licensing, transfers, or partnership. Okay, and I have useful links for you, which you can use further after the end of this session. The materials will be posted. Well, in general, I encourage on applicants to be precise, yeah, and basically that's your own business decisions and your own business intelligence for your business model. So that's important to draft it in the first place for your company, right? Not only for the project, but that must be for any business model. Okay, thank you. Thank you for having me. Good luck to applicants.